Now we consider the preliminary or inchoate offenses. These include solicitation, conspiracy, and attempt. This material also can get fairly complicated, but in the big scheme of things, it's not terribly important, and the way it is tested actually is reasonably straightforward. So let's consider solicitation first. Solicitation is where the defendant incites, advises, encourages, or orders somebody else to commit a crime. The defendant must have the intent that the other person will commit a crime. And in urban areas, the most common solicitation offense is where the defendant solicits an act of prostitution from typically an undercover police officer, is how the case makes it into criminal court. But solicitation can apply really to any crime. So where the defendant, for example, tries to hire a killer, that act is the solicitation of the criminal act of homicide. Anytime the defendant asks, encourages, or advises somebody else to commit a crime with the intent that that third party commits that crime, solicitation has been completed. And suppose that the person that has been solicited agrees. Typically, that agreement constitutes conspiracy. And at the moment that there's been a conspiracy, the crime of solicitation will merge into the conspiracy. Okay? Well, let's consider conspiracy separately. Conspiracy involves an agreement involving two or more people with the specific intent to enter into the agreement to commit a crime. And again, there must be the specific intent to complete that target offense. And then we get into the somewhat more complicated area of the overt act. At common law, an overt act was required to establish conspiracy. Modernly, it is not. Also, there are defenses to conspiracy. Now, let's consider the defenses. We will talk about impossibility, and we'll consider it below at some length when we consider defenses. But it's important to realize that impossibility is not a valid defense to conspiracy. And when you look at it a little bit more carefully, you'll see that beyond impossibility, often we will be faced with issues of withdrawal. So a defendant will agree to commit a crime and then will back out before the crime has been committed. That is a defense to liability for the underlying crime, but it isn't a defense to conspiracy, because the conspiracy is completed at the moment that the defendants enter into their agreement. And so a subsequent withdrawal does not get rid of the crime of conspiracy. Now, modernly, there are some statutes that will allow for somebody who both withdraws from a conspiracy and then thwarts the ultimate crime to escape liability for conspiracy. But that's a modern statutory refinement. The common law is much more black and white, and once the conspiracy has been completed, we've got an agreement. If a defendant later withdraws, it's a defense to criminal liability for the target offense, but not for conspiracy. Notice also that an underage person can't be found liable for a conspiracy to commit statutory rape, since that person is the victim of the rape and doesn't really have the power to agree about anything involving the act of sex. All right, now let's turn to what probably is the most complicated area of inchoate offenses, attempt. Remember that the basics of attempt involve an act that is done with the intent to accomplish a crime. Also, an attempt can be an act which actually falls short of completing the crime. Here again, it's important to acknowledge that attempt is a specific intent crime, not a general intent crime. So, as we consider defenses below, voluntary intoxication can be a defense to all of the specific intent crimes, and that includes the crime of attempt. Now, the most complicated area of attempt really doesn't arise from the prima facie case elements of attempt. Those are fairly straightforward. The most complicated part of this material comes from the defenses of factual and legal impossibility. And again, we'll consider them in a little bit more detail when we get to defenses. But for our purposes here, we need to acknowledge that these issues exist, and I'll encourage you again, refine your knowledge through practice, not through abstract study. Factual impossibility is not a defense to intempt, but legal impossibility is. Remember, if the act is legal, defendant's subjective belief in its illegality is not enough to establish attempt. Another defense to attempt is abandonment, and very commonly we can avoid liability for attempt, ironically enough, by being guilty of the target offense. Once we've committed the target offense, the intent charge goes away. Now, before we get to our next video, which will consider defenses in more depth, I want to acknowledge that there's one more little pocket area of crimes, and these are crimes that involve the courts or the government. Perjury or the suborning of perjury, the hiring of perjury, are both crimes, and so is bribery, another crime against the government. Compounding a crime, or misprison of felony, being an accessory after the fact, also is enough to give rise to criminal liability. And that wraps up about as concise a consideration of the inchoate offenses as you can hope to see. Next, we'll consider defenses.